Yeah, okay. All right, ladies and gentlemen.
Yes, sir.
Thanks. All right, folks, good morning. We are on the record today for the 28th Circuit Court for Wexford County. And we're going to first take up two cases that are both entitled People of the State of Michigan versus Andrea Lynn Downing. These case numbers are 23-13638 and 13639 FH. Appearances, please.
Good morning, Your Honor. Corey Wiggins on behalf of the people.
Good morning, Your Honor. Caitlin Koshiba appearing on behalf of Andrea Downing, who is present on Zoom.
Thank you. Ms. Downing joins us today via Zoom from the Michigan Department of Corrections Confinement Facility. Ms. Downing, are you able to see and hear the court, ma'am?
Yes, Your Honor.
All right, thank you. We are here today for two purposes. First is for a final pretrial conference. However, we're going to actually take up the second reason first, which is a motion to withdraw as counsel in this case. The court had received that motion and a draft order. Looks like a couple weeks ago, maybe back on the 22nd of January. And I had it set for a hearing. Actually, there was a stipulation presented. I'm sorry, a stipulation presented earlier. Looks like it made it to my office back on the 17th of January. And I wanted the matter set for a hearing. The reason for it is only because Ms. Downing is in the Department of Corrections and she wasn't a part of the stipulation. And I just wanted to make sure that she was in the loop and didn't feel like she had no idea what was going on with her case. So I have that stipulation. We'll ignore that and then we'll just take it up as a motion, which I have received. Ms. Koshiba, you don't need to, but is there anything else you wish to say? Argue?
Just for the record, I'd like to just state that I'm not MIDC qualified to handle this case. With all of the charges being back on the table since the plea had been withdrawn, the fourth offense notice makes that Ms. Downing's case a potential life sentence. And I've only done one jury trial in misdemeanor court that went to verdict. And therefore, due to the Michigan rules of professional conduct, I believe that this case should likely be appointed to alternative counsel. Thank you.
Thank you. Mr. Wiggins, anything to add?
Your Honor, I'll just, I know Ms. Koshiba cited the rules of professional conduct in her motion. I believe those are appropriate. I would also agree that pursuant to the Michigan Indigent Defense Standard 7, which appears to have been passed back in October, in order to have a life offense case, interestingly, lead counsel must have no fewer than 7 felony trials.
Yeah.
Now, unfortunately, they don't tell us what happens when we don't have attorneys that meet that qualification, as in small areas like we are.
Yeah.
But I think with what we're dealing with, I would agree that it would be appropriate to allow her to withdraw as counsel.
When I read those rules, I wish they also answered a different question. Does that life offense language apply to the charge or when there is an enhanced sentence left to the discretion of the court? For instance, if a life offense such as just murder with no habs, for example, is brought to the court, we know that that is carried, for instance, the attorneys have up to more peremptory challenges, for example, and that the life offense gets treated differently because of its basic predicate maximum punishment. However, it doesn't become treated as a life offense in that example, if there is an enhancement that makes it a life offense. I wish the instructions, I'm sorry, the rules that the parties have referenced covered that. They don't.
They don't, and I will say in this case, though, Your Honor, even if the life offense is off the table, it is still a high severity felony, which requires, I think it was 4 trials at that point.
Yeah.
That the council had.
Yeah, that's where I was going to go next. So that no matter what, I still think we have a concern. All right, so now, Ms. Downey, I'm going to turn to you. I should have asked, which I think I already know the answer because I've heard you breathe. Are you able to see and hear us today, ma'am?
I am, yes.
All right, thank you. Now, a couple things I'm going to state before I ask a question here. You are currently serving a period of confinement in the Michigan Department of Corrections from a sentence, not from this court, but from another court and another case. Is that correct?
That's correct, Your Honor.
And when is the minimum release date on that case that keeps you there?
That would be the year 2030.
All right, thank you. So the only reason for asking that, Ms. Downing, is because when determining what we're about to determine, I need to look at prejudice, and I also need to consider the speedy trial clock rights that are ticking. And I find now, based upon that information, that there is no prejudice or speedy trial clock violation if I were to grant the motion to withdraw. And it might take some time for another counsel to be appointed and for that attorney to catch up on the case. Now, I'm going to turn to you and see, do you have anything to state in regard to the council's petition to withdraw?
Just that I was happy with her counsel. I think she's doing a great job.
Well, and I appreciate that. I'm sure the council appreciates that. As you know, and as we clearly covered on this record, there was a slight hiccup, and it's one that even counsel with more trial experience would have possibly missed. In fact, I don't remember if we knew at the time you had been on bond and so forth, but the issue that resulted in the potential concurrent, consecutive sentencing issue arose. It's one of those rules that doesn't always come into play, so I don't necessarily hold that against anybody. And we've handled it appropriately to get to where we're at today. Now, if the county had the money and the resources, I would strongly encourage the conflict office or the public defenders program to allow Ms. Kashiba to assist. I think that would be beneficial to Ms. Kashiba, as it would be to any counsel. I think it's sometimes they need to sit second chair on a bigger case before they represent somebody on a bigger case. However,
Absolutely.
yeah, and so I just think that's appropriate. So here's what the court's going to do. The court will grant the motion to withdraw based upon the information that's been presented today. The court will refer the matter back to the Wexford-Missaukee Indigent Defense Commission, also known as the Public Defender's Office. And because Ms. Kashiba must have been appointed because there was a conflict, because there must have been multiple defendants, I don't remember. It will probably go back to that conflict attorney who will then coordinate. We call him a conflict coordinator, sorry, and he'll probably appoint another attorney. However, I'm going to encourage Ms. Kashiba, which of course it's all up to you whether or not they can afford it, to see if you can sit second chair, and maybe it's only sit second chair during the trial. If there is a trial, I mean, I don't know what's going on with the case, and maybe spend time talking to that other attorney. I think that would be beneficial. I know I spent several of my first couple of years sitting a lot of second chairs, and I've got some good stories I can share with you about one where I I made a comment in the military courtroom where it kept everybody laughing at me because I was too young. But anyways, that's okay. I encourage everybody to get as much experience as they can. All right, so the court hereby grants the motion to withdraw as counsel. The court will refer the matter for appointment of an attorney. I do not find that there is any prejudice and any delay. So now we're going to turn back to the final pretrial conference. The court hereby adjourns the final pretrial conference as it would be inappropriate to hold it, because at final pretrial conferences, I expect the case to be either resolved with a plea or set for trial. If it's set for trial, then that's going to be in about 2 weeks. And I guarantee whoever takes over Miss Downing's case is not going to have enough time to prepare for a trial in 2 cases that involve these types of offenses. All right. Anything else, Mr. Wiggins?
No, Your Honor, thank you.
Anything else, Ms. Kashiba?
No, thank you, Your Honor.
Ms. Downing, do you have any questions for us today?
So I will get the prosecutor will offer me a plea. It's starting over again.
The answer to your question is most likely yes. And here's what I mean by that.
Okay.
When I say the word most likely, you must remember, I am the neutral officer in the court. I cannot tell you that the prosecutor will do that. I cannot tell the prosecutor to make an offer. However, I highly suspect, based upon 28 years of being an attorney, that I trust he is going to reach out to the new defense attorney and probably discuss possible resolutions of the case.
Okay.
All right. Yep.
Thank you.
Yeah. So I'm sure that will take place. And yeah. One thing to think about, if there is a plea or a fine, you may not get credit for the time that you're sitting, because I can't give you credit in this case if you were to ever plead or be convicted while you're serving a sentence in the other case. Make sure that you make sure you talk to whomever your attorney is going to be about, if you decide, and please don't comment if you do, if you decide to resolve this case short of a trial, make sure you talk to him or her about that, because right now you're not earning credit.
Okay.
All right, good enough. Now, I'm not going to say anything more about it, but you're that, as long as you bring it up to your attorney, they're going to know what to say to me later on. All right. Anything else, Ms. Downing?
No, Your Honor.
All right, thank you very much. We are adjourned.
Thank you.